Regular, thank you. Corrales Governing Body Special Meeting called for September 16th at 5:30. I'm going to call the meeting to order, and then I'm going to do a roll call before we move into our sole issue before us tonight. So Councillor Knight.
Here.
Councillor Waldman.
Here.
Councillor Murray.
Here.
Councillor Parker.
Here.
And I'm looking, who am I looking for?
Councillor Burkett.
Councillor Burkett.
Here.
There you are, thank you. Is Councillor Lucero here? I'm sorry. Somebody's gonna have to mute their phone, please. And is Councillor Lucero with us? All right, I don't think he's with us at this time. So I'm gonna ask for a motion to approve the agenda. Do I have a motion to approve the agenda?
So moved.
Thank you,
Second.
Councillor Murray. Do I have a second?
Second.
Thank you very much. Everybody signify aye by raising their hand and saying aye.
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 Any opposed? Well, I know, Tyson, I can't really see you, but you said aye, correct? Any opposed? All right, thank you. Then we're going to move on into our appeal process. We're going to move on to the one item that we have under new business. This is a hearing of an appeal to the governing body of a denied building permit at 66 Bad Coyote Place. My name is Joanne Roque. I'm the mayor for the Village of Corrales, and I will be functioning as the presiding officer of this meeting. The hearing today is a quasi-judicial hearing, and the decisions will be made by the members of the governing body. I'm going to conduct another roll call for the record of this appeal. Councillor Parker?
Here.
Councillor Parker, here,
Here.
thank you. Councillor Knight?
Here.
Councillor Burkett?
Here.
Councillor Murray?
Here.
Councillor Waldman?
Here.
Councillor Lucero? All right, thank you very much. Now I'm going to ask that the appellant to please identify yourself. Mr. Ken Dehoff?
Good afternoon. Can you hear me okay?
I certainly can. Thank you very much. The scope of this appeal will be limited to the application for a building permit at 66 Bad Coyote Place and the subsequent denial by planning and zoning. I'm going to tell you that if you go outside of that scope, I'm going to call you on it and I will say that is irrelevant. That goes for both parties as well as counselors unless it is really related to the application and denial. We are recording this meeting tonight so that a complete, clear record can be created of everything being said. However, please remember that we cannot create an accurate record with people talking over each other. So I'm going to be strict about people talking over one another. If you start to do that, I will stop them so that we can get a clean record. The council will have the opportunity to ask questions. Council, if you have any questions, could you please make sure that you say mayor so that I can make sure that I see you, recognize you, and let you speak. Again, that is for the record and so that we get those questions and answers down. The questions should be focused on clarifying the record or the testimony given and should not include any new information or evidence being offered by a counselor through the asking of a question. I'm also going to assume that everyone's demeanor is going to be appropriate and there will not be any badgering or argumentation of witnesses. I will also not tolerate any personal attacks by anyone during this proceeding. If this happens, I am going to point that out and stop it so that we can get back to a civil proceeding. Witnesses and evidence. Evidence in this hearing is made up of everything in the record from the planning department and what is introduced for the first time here tonight. Evidence includes testimony and exhibits. If either party has exhibits to present that are not in the packet, please email them to Aaron so that they can be presented to council. All right, here's the general outline of how the hearing will proceed. We'll first have a background statement by Planning and Zoning Administrator Lori Stout, just to give the governing body an outline of the case consisting of a review of the application and the P&Z's Commission's denial of the permit. Each party's time will be limited to 20 minutes. The appellant may request more time if the matter being heard is extremely complicated, and upon their request, the governing body agrees. Do you feel at this time that you will need more than 20 minutes?
Yeah, about 25 minutes, if that's okay with you.
I think that's a reasonable request. Does the governing body concur with that generally? Signify by putting your hand up. All right, thank you very much. The appellant may present argument or call witnesses, and any of their witnesses will be sworn in by the village clerk. The appellant can rely on the record of the exhibits and witnesses from the P&Z hearing or introduce new exhibits or call new witnesses. If there are exhibits, those again should be given to Aaron Yulin. You will need to explain what the exhibit is, and the appellant should offer the exhibits into evidence, and if they are related to the case, they will be made part of the record by an act of myself, the mayor, unless an objection to the evidence is raised by a counselor. At the conclusion of the appellant's case, we will then move on to the appellee's case. At the conclusion, if the planning and zoning, if Mr. Dehoff has reserved any time, you may use it as a final rebuttal. Counselors or I may have questions of the witnesses limited to clarifying the evidence, the parties' arguments, or the decision of the P&Z. No independent evidence should be offered by counselors or I, and I will remind us of that if necessary. After questions, I will close the hearing if requested, and the governing body will deliberate, and the village council may make a determination in open session or decide to deliberate in closed session as allowed by the Open Meetings Act. All decisions must be made in public. The governing body may grant the appeal and reverse the P&Z decision, deny the appeal and affirm the decision by the P&Z, modify the decision with new findings or remand the case back if the record before the governing body is not sufficient to ensure its decision will be in compliance with village or the governing law. Once a decision is made, then there will be a direction to our attorney to prepare a written decision and findings of fact and conclusions of law supporting the governing body's decision based on the facts established in the record. The hearing date shall be set at that time for a vote on the form of decision as soon as practicable. After the approval of the final decision, the appeal will be concluded. All right. Unless I have any questions, we are now going to proceed. Director Stout.
Thank you, Mayor, councilors. In order to understand the basis for the denial, I just wanted to give you a brief preview of how we got there. As you know, this council passed revised definitions of dwelling unit, accessory structure, and kitchen fairly recently. The definition of accessory structure works, makes it clear they are to be barns, garages, with the language not to be used as a second or independent dwelling unit. I want to thank you for that and for that clarity. That's very helpful. However, a change to the definition of dwelling unit that was added that night is causing some heartburn in the planning and zoning department, specifically the word connected. So right after it was passed, the building official and I grappled with the meaning of connected. It was his view that a strict reading of the new ordinance is that 2 or more areas, each with bedrooms, kitchens, bathrooms, need only be just that, connected in some manner. Not long after, a citizen who is an architect came in with drawings of a duplex, triplex, and a fourplex. He said, these are connected. And is this now what is going to be allowed by the village? As you know, the village still has 1 dwelling unit per lot as a staple in our comprehensive plan and our ordinances in all zones. So folks who originally wanted casitas saw that it would not now be allowed, and a few plans with duplex type configurations started coming in lieu of that. So we were really struggling with this. We thought it through some more. And I ran the phrases same contiguous heated square footage and all living areas potentially accessible through the same primary entrance past our counsel, Mr. Audio. He agreed that interpretation would be enforceable. So same contiguous heated square footage, all living areas potentially accessible through the same primary entrance. The first set of building plans I saw from Mr. DeHoff had a house with a kitchen, bedroom, living areas, and on the other side of the garage, another living area with kitchen, bedroom, bathroom, attached to opposite sides of a garage, not the same contiguous heated square footage or same primary entrance. I denied those plans based on the fact it was 2 dwelling units. And I really, here, I can't stress enough, if the village approves plans with that configuration, we will open the door wide for duplexes and triplexes and unlimited, perhaps no limit, as long as the different units merely touch one another. So after the denial, excuse me, the DeHoffs came to the next council meeting and expressed their desire through testimony to you to have the second kitchen for rendering produce from the farm and this other bedroom so that someone could keep an eye on the farm while they were away. That, I believe, seems allowable under the new ordinance, with the caveat, same heated square footage and primary entrance as the rest of the house. I also thought it was prudent from that point forward to have all conversations with the DeHoffs conducted via email and letter. So I'd like to read you a letter I then wrote to the DeHoffs. It says, on June 15th, 2021, Village Council passed Ordinance 2104 to hopefully clarify the one dwelling unit per lot that has been a backbone provision in the village since 1972. The new definition language for dwelling unit includes the words a single unit with connected rooms and each of the following uses: living, sleeping, eating, cooking, and sanitation. It was made quickly clear that an interpretation would have to be established right away to what connected means. It means all rooms are part of the same contiguous heated space and are accessible through the same door. That doesn't mean a house cannot have back doors or side doors, but that all rooms within that dwelling unit are accessible through a main entrance, wherever it may be. That is to prevent duplex, triplex, and other apartment scenarios that have crept up, in addition to the instances of separate dwellings or separate structures, each becoming dwelling units on one lot. On Friday, July 16th, I was shown your drawing that showed a casita that, while attached to the side of the garage, had a separate entrance and was not accessible through the house in any way. It contained a bedroom, bathroom, kitchen, and what you've called a small workspace. That constituted a duplex type dwelling and is not allowed under code. On the afternoon of July 20th, 2021, I was shown a different drawing where the same area now had the rooms labeled office, shop, and bathroom. At that night's village council, Mrs. DeHoff testified, we have intended and designed our casita to facilitate our farming. Kitchen will be where we clean, render, dry, prepare our crop. Also, we have designed the kitchen in the casita to do this so we aren't hauling hundreds of pounds of produce through the house. You also state you put a bedroom in the casita so that when you travel, someone may stay there and tend the grounds and farm. I put these statements in here only because it does not now match the drawing. We have since received another drawing today, July 21st. It shows the same approximately 600 square foot area with rooms, still labeled office, shop, and bathroom, but it has now moved south and with a double-sided door connecting it to a room marked utility dog room. In order to know exactly what we were being asked to approve, please answer the following questions in writing so that there are no misunderstandings. Which of the three drawings you provided is to be considered? Are the rooms going to be used as kitchen, bedroom, shop, office? Please be specific. How many total bedrooms do you wish to have in the house? Are there going to be any bedrooms in the detached garage or the barn? With this information, we should be able to make a decision, but if not, I will email you promptly and clear up any lingering questions. I look forward to your reply so that we may resolve this for the benefit of all parties. Then there were just a few series of emails. I was just trying to get the answer, I guess. I sent an email to the DeHoffs, or to Mr. DeHoff rather, on July 23rd. Our building official has two drawings. Which of them do you wish us to consider? One shows the building at the side of the garage in a different area than the other. And one is
Lori, could you hold on one sec? Thanks. Aaron, I could have been looking at something else at the beginning, but did you swear Lori in?
Mr. Audio, I don't believe I did. I think I forgot. I will do that right.
Could you please swear her in?
Yes, I apologize for that. Ms. Stout, if you could raise your right hand. Do you swear and affirm that everything you've said up to this point and everything you will be saying is true and nothing but the truth?
I do.
Okay, thank you. I apologize.
Oh, that's okay. Okay, I guess I'll just start with this email again. Our building official has two drawings. Which of them do you wish us to consider? One shows the building at the side of the garage in a different area than the other. On one, it's connected to the heated square footage of the house, and on the other, it's not. On both, the rooms in the building to the side of the garage are labeled shop, office, and bathroom. Have you decided not to pursue a kitchen and bedroom in that area after all? It's your choice, of course. The response I received from Hendy Hoff, the one that is connected to the heated square footage of the house is the version to be reviewed. My response, is it your intent now to not pursue the bedroom and kitchen in that area? It's allowed now that it's part of the heated square footage of the house. I just need clarification, please. The response, whatever gets us our permit, we prefer the areas to be assigned as a bedroom and kitchen if that will not invalidate our submission. And now I promise I'm almost done. So that brings us to the approved plan that I have in front of me. What I approved shows a 2-bedroom house with kitchen, bathroom, living areas, with the other separate area in question labeled as bedroom 3, also containing a kitchen, a bathroom, and a shop. That area is attached to the garage, but now also has a side door connecting it to a room labeled utility/foyer/dog room. It appears to all be part of the same contiguous heated square footage and potentially accessible through the primary entrance. On that basis, that plan was approved and a building permit was issued in late July, paid for on August 5th, 2021. Thank you.
I guess I have a question just for clarification. Can you just contrast that with the plan that you denied?
Certainly, Mayor, councilors, the one that was denied was not attached to the same heated square footage. It touched the garage. It was not a part of the house. And you couldn't go in the primary entrance of the house and get to that area.
Thank
And
you.
this one you can.
All right, thank you very much. Before we move into the appellant, does anybody have a question? Any of the counselors have a question for Ms. Stout? Counselor Murray.
Thank you, Mayor. So Ms. Stout, I'm confused. Which drawings are we supposed to be looking at for this hearing?
I'm going to have to defer to Mr. DeHoff. The one that I approved, the rooms are labeled correctly as a bedroom, kitchen, bathroom, and are part of the same contiguous heated square footage and accessible through the primary entrance. So that's what I approved. So I'm not sure.
Is that in our packet? I'm confused about what's being presented as, as part of our hearing.
Again, I'll defer to Mr. DeHoff since he filed the appeal.
All right, I will get clarification from him immediately. Does anybody else have a question before I put that to Mr. DeHoff? Mr. DeHoff, could you help us and the governing body by clarifying what drawing is at issue here tonight?
I have put a package together, and in the package, there are the specific drawings. Aaron was gonna share those while I was going through this, but is that not going to be possible?
No,
it is, Madam Mayor.
One second again, I'm sorry, but Aaron, would you swear in?
We do
Mr.
have to
DeHoff
swear
at this
Mr.
time?
DeHoff
Yeah.
in, yes.
Yes, Mr. DeHoff, I'll trust that you're raising your right hand. Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
Okay, great. Thank you. Madam Mayor, Council, I believe I can share what I believe Mr. DeHoff is talking about. I'll share it right now, and hopefully he can enlighten me just to make sure that it is the correct. This is part of the packet that was submitted this afternoon and was sent to you around 2:30 and is here available tonight. So this is, I believe, Mr. DeHoff, is the approved set of plans that you are discussing. Is that correct?
Yeah, that's the one at the bottom of the file. Yes, that's the approved plan. It's not the entire floor plan, it's just the area that is the point of discussion.
Right here. Right,
I think what the counselors are interested in is what is the one that you are, because this was approved. So what is the plan that was not approved that you've brought us here together to discuss tonight?
Can I go through my testimony, or are you gonna,
Well, I think it's a fair point for the counselors, if they understand which plan it is that you are
okay.
concerned
so
about that you
go-
didn't get approved, it
So
will help them.
it's in the document. It's at the very, like page 3 of this document. There are these plans. So that's the original plan, the July 16th submission. And you
Okay.
notice that that hallway through the garage does not exist there.
Okay, so this one didn't pass, did not get approved by the planning and zoning director.
Right. Nor did the next one below, which is the
Okay.
same floor plan, but it has a different use case.
All right, does that clarify it for you, Counselor Murray? You're muted, sorry.
All right, yes,
right.
I think so. So,
Okay,
but what we're working on is the denial by the Planning and Zoning Commission on these two drawings.
Correct.
and then Counselor Burkett, did you have something you wish to have clarified as to this same point?
So we're evaluating both of these denials or just
No.
one of them?
Just the one,
The shop one or the casita one?
the casita one, the
Okay,
first
so the
one.
first one.
The first one.
Okay, so this is it. Could we, Aaron, for the record, can you identify what page this is
Yes,
in
Madam Mayor.
Mr. D. Hoff's materials?
Yes, this is in the supplementary information that was submitted to me this afternoon, and it is page 3 of 13 that we are discussing at this moment.
All right. Thank you. All right, Mr. D. Hoff, I think now that we have the scope of this clarified and what it is we're looking at, please go ahead with your presentation.
All right. For anyone that's on the bridge that may not have access to this document, it's on our website at www.badcoyotefarm.com if you want to follow along, and the supporting documentation at the end of the file is also available. So what I've got is a prepared statement that's 25 minutes long, as long as I am not interrupted. Interruptions will modify that.
That's true. However, I do believe that the council is entitled to stop you and ask you a question. And I think that's probably to your benefit because it means that, you know, they may not remember as well. So if somebody calls my name and asks me, I will allow them to ask you a question. But
All
please
right.
go ahead and start, please.
It's your meeting. All right.
Your appeal, sir.
Thank you everyone, neighbors, for taking the time out of your evening to hear our appeal. My wife and I are here to appeal our 2 building permit denials that we consider were done capriciously, arbitrarily, and in conflict with Corrales precedent, state and constitutional law. We have been told that we were attempting to build 2 dwelling units, which is a violation of code as specified by the new ordinance 2104. We had 2 plan submissions denied by Lori before a 3rd version of our plans was approved when we modified them to add a door, heat, and a hallway based on Lori's requirement that all rooms are part of the same contiguous heated space and are accessible from the same door. We are asking that our initial July 16th plans be approved without the door and hallway modification. Further, we believe Ordinance 2104 changes Section 18 to be in violation of state law, making sections of it invalid, and recommend the removal of 2104's changes. We have 5 arguments that capture the fatal mistakes made by Lori and the village. Our standard of review is to show the denials were arbitrary and capricious. The denials were not supported by the facts and exceeded authority granted by the state, and the denials were not in accordance with state law. I will quickly summarize the 5 arguments before drilling down on each one. I have provided reference materials at the end, including links to relevant documents and communications, and also links to citations in New Mexico court opinions that support the points that I am making. And I include the approved casita portion of our plans as well. First point, Ordinance 2104 outlawing accessory dwelling units does not apply to our plans simply because we aren't trying to build an accessory dwelling unit. Section 18 as applied to our plans was arbitrary and capricious. We submitted 2 versions of our plans, one as a casita, the other with the same physical space called a shop. Lori denied both, saying they were not properly connected. There are 2 problems with her connected definition. Law doesn't allow for extreme redefinition of common terms like connected. And on June 28, she approved plans for a home with a casita, much like ours, not connected in her required manner. In addition to this, the new dwelling unit definition states a dwelling unit must contain 5 features and be independent, while our casita only contains 3 of the 5 and is not independent. Section 18 is in violation of state statute and hence invalid and unenforceable. State law requires municipalities to provide for multi-generational housing, but this was never offered to us as an option. In addition, the state expects municipalities to abide by their comprehensive plan, and the Corrales Comprehensive Plan from 2009 mentions both casitas and accessory dwelling units favorably, and also states the village was working, back then at least, to support multi-generational housing. Finally, state law expressly grants how municipalities are allowed to restrict land use and for what reasons. And controlling floor plan and mechanical design does not make that list.
Mayor, this is Councilor Murray. Quick question.
Yes, Counselor Murray.
Thank you. Mr. DeHoff, when you refer to section 18, what part of our ordinance is that referring to? Is that in chapter 18 or what chapter is that in?
That's chapter 18, your zoning chapter.
Thank you.
Ordinance 2104 is unvalidated, invalid, and unenforceable, hence unusable as justification for denying our permit. The ordinance was passed following Corrales' Procedures 261. Unfortunately, 261 is less restricting for passing laws than the state requires. Steps were missed relative to state law that makes 2104 invalid and unenforceable. And then finally, execution of both denials deprived us of due process in violation of the 5th and 14th Amendments of the United States Constitution, as well as the Corrales Village Code. Procedural due process requires that we be given enough information about our denial so that we can effectively respond to that denial. The Corrales Code section 1845A3 mirrors this. However, we were only ever given broad complaints to work with and never any reference to the village code. Only Ordinance 2104. I'd like to walk through just very quickly the calendar of the denials so that everybody has my perspective of the key events. This started Friday, July 16th, 5 p.m., where I submitted our initial plans to Joe. Monday morning, 9:33, Joe called me with the first denial and explained that I had to talk to Lori. So at 9:36 that morning, I called Lori and had the first phone call denial. 10:30, I emailed an appeal for help to the mayor. At 10:45, the mayor forwarded my appeal for help right back to Lori and included Ron on it. And at 11:20 a.m., Lori responded to that. I consider that her first denial. I retrieved my plans from Joe at 4 o'clock on Monday. And 8 a.m., I submitted the second plan set to Joe. 4 p.m., Joe emailed the second denial, and I went back at 4:30 and got the plans from Joe. And then 5:30 that night, my wife and I spoke at the commission meeting. Lori's already spoken to many of those details. 8 a.m. Wednesday morning, I sent a registered letter to Lori. 9 a.m., I emailed a single-page what-if proposal drawing to Joe via email. 4 p.m. On Wednesday, Lori emailed her denial explanation letter to us. Thursday, 9 a.m. on the 22nd, I submitted the plans with Lori's hallway that she has referred to. And 2 o'clock, August 5th, we had our signed plans paid for. So point one, Ordinance 2104 does not apply. Between Resolution 2103's 6-month moratorium that expressly targeted accessory dwelling units and the language of 2104's preamble that repeatedly calls out concerns of accessory dwelling units, never mentioning apartments or duplexes, it is clear from the legislative record that the ordinance was intended to keep accessory dwelling units from being constructed. Given we do not propose an accessory dwelling unit, and Lori's assertions that we are building either an apartment or duplex, it should be obvious that Ordinance 2104 cannot apply to our circumstance. But obviously,
Councilor Murray, a quick question again. I'm sorry to
Yes,
interrupt.
Counselor Murray?
Thank you. Mr. DeHoff, how do you consider 2104 invalidated if it was duly passed by the council of this village?
I'll get to that detail in another point.
Thank you.
Point two, was there another question?
I don't see any other
All right,
questions from
okay.
counselors.
Point two, Section 18, as applied to our plans, was arbitrary and capricious. Our two denied plan submissions include the same area referred to as either casita or shop, and you can see those images. The first submission of July 16th referred to the area as a casita with a casita kitchen with no appliances, which was consistent with the prior Section 18. The second of our 3 bedrooms and a bathroom. Lori denied this submission, calling it a separate apartment with a kitchen that is connected to the garage but not connected to the rooms of the house. The second submission on July 20th referred to the same physical area as a shop with a workbench and an office and bathroom. And we've reduced the bedroom count on the permit from 3 to 2. Lori stated after denying the second submission that connected means all rooms are part of the same contiguous heated space and accessible through the same door. It is clear in view of these 2 denials that the village takes a capricious and arbitrary approach to enforcing Section 18, such that no reasonable person will be able to guess at what may be considered valid. How can anyone call a shop with an office, a dwelling unit, or a kitchen with no appliances a place to cook? Since Lori has never cited any specific village code section, we are left to infer that she believes our house design is not a single unit dwelling unit. A recent conversation with Ron Curry and Randy Audio support this, as they referred to our supposed intent to build 2 dwelling units as they were attempting to dissuade us from making this appeal. But an exact reading of the dwelling unit definition using Lori's substitution yields a different problem. A single unit with all rooms a part of the same contiguous and heated space and accessible through the same door. 25% of our envelope was designed as unheated, not including the garage. This seems a significant change from the existing ordinance, and if this is your intent, why was it not included in the ordinance? Is the precedent of always requiring contiguous heated space accessible through a single door in Corrales so clear that it does not need to be stated? Lori never brought this up at the June 15th adoption hearing. She was at the podium for most of that discussion and had ample opportunity. None of you brought it up either. She did add single unit with connected rooms from the existing ordinance and stated this does not change existing policy, but will prevent people from sneaking in an apartment. So that's what she thinks we're doing. I suggest it is Lori sneaking something in. You might be tempted to laugh this off as Lori's naive mistake, but she is the planning and zoning administrator and used her authority based on this phrase to deny our permits twice and compel us to comply with her version of the law if we ever wanted to build on our own land, which added significant reengineering costs, construction costs, and scheduled delays, not to mention the scores of man hours we've spent preparing for this appeal. Lori asserts this connected problem in both denials, but this is provably incorrect. If we limit ourselves back to the plain meaning of connected, and Lori used this plain meaning of connected at the June 15th hearing twice. She used it when she added the term single unit with connected rooms to the dwelling unit definition, and then again in the discussion with Vanessa Santo to describe how an elderly parent will be able to live with her. Lori said, someone can have a separate suite for their loved one. It's just connected to their existing house. It's just not going to be a separate dwelling unit. Second chance that night, no mention of contiguous and heated floor space or a common door. And when I checked with Vanessa, she understood Lori's comments the way I think we all do, physically connected, part of the same building. I considered the redefinition attempt of connected in her July 21st letter to us to be invalid under state law, and her desire to interpret the ordinance to add it in is evidence to the fact that our floor plan is in compliance with the language and intent of the ordinance as written, and we are in line with long-standing Corrales precedent. The plain language test of statutory construction precludes any redefinition of the term connected, and statutory interpretation is not required or available because the language of the dwelling unit definition is unambiguous and makes sense as written. We have discovered that Lori approved a casita with a bedroom on June 28th that was connected by a covered patio, much like ours, and not a contiguous and heated floor space accessible through the same door as she expects of us. And you'll see that image if you look below this paragraph. If this casita was approved on June 28th, why was our casita not approved on July 19th? While this approved non-contiguous casita appears to be in line with long-standing precedent of allowing such buildings in Corrales, does there exist any other permit denial because you required all rooms of a single dwelling unit to be connected by the same contiguous and heated floor space accessible by the same door? Are we the first? No, we are the only. Turning to the second component in Lori's denials, in declaring we have multiple dwelling units, it appears to be her assessment that our space is independent and complete, making it a dwelling unit. However, the space is neither. Since the language of the dwelling unit definition is clear and unambiguous, it must be read using the plain meaning of the terms within and is not subject to interpretation. Our home is a dwelling unit because it is a single unit with connected rooms providing complete independent living facilities for one or more persons, including permanent provisions for each and every one of the following uses: living, sleeping, eating, cooking, and sanitation, and it is a site-built house. And the corollary conclusion is our casita is not a dwelling unit because it is not a single unit with connected rooms intended to provide complete independent living facilities for one or more persons, because it does not include provisions for each and every one of the following uses: living, sleeping, eating, cooking, and sanitation. Specifically, it does not have any permanent eating or cooking facilities, and it is an integral part of our site-built home. And to expound further, it shares curtilage, all physical, mechanical, and other systems with the other rooms of the house, unfettered dog access between all house areas, and I guarantee Sandoval County is going to be taxing us as a single home. Our home is thus a single-family dwelling unit and a permissive use under Village Code 1833 2A. Section 18 is in violation of state law and invalid and not accessible to enforce NMSA 321(1) F and G. Zoning authorities shall accommodate multi-generational housing by creating a mechanism to allow up to 2 kitchens within a single-family zoning district, such as conditional use permits. Since our first submission included 2 kitchens on the plans, and if our 2 dwelling units were so obvious to the village, and the state mandates that you must provide this, why wasn't this an option for a special use permit ever discussed? Even Randy and Ron never suggested this as a compromise. Corrales Village Code 1845-3 requires that you should have made this known to us if allowed. The comprehensive plan from 2009 stated you were working to provide this. I guess it's still a work in progress. Without this accommodation anywhere in Section 18, Section 18 is inconsistent with state law. NMSA 321(1)A sections 1 through 5, for the purpose of promoting health, safety, morals, or the general welfare, a county or municipality is a zoning authority and may regulate and restrict within its jurisdiction height, number of stories, size of buildings and other structures, percentage of a lot that may be occupied, size of yards, courts, and other open space, density of population, location and use of buildings, structures, and land for trade, industry, residential, or other purposes. And consistent aesthetics is routinely added to this list. Municipalities are expressly granted all authorities by statute and MSA 3. They include eminent domain, policing, floodplain management, and planning and platting and zoning, and several others. NMSA 318-6A authorizes you to prescribe standards for constructing and altering buildings within your planning and platting authority, which grants extensive authority to determine what goes on inside a new building using NMAC and other building codes. But the state does not authorize you any ability to enforce floor plans or heating requirements within your zoning authority. They are not on that list. How does Lori's heated hallway in our house promote health, safety, morals, or the general welfare? What's the link? NMSA 317-3A, requiring notice by publication of the title and subject matter of any ordinance proposed for adoption. That requires, and I emphasize, and the title and subject matter must be published. Was it maybe misuse of a boilerplate that had you declare see title for subject matter in the notice? Because you did not communicate at all your intent to outlaw accessory dwelling units or the intent to assert new floor plan and mechanical design requirements in the journal notice. And then there is also the problem of the ordinance preamble, never mentioning why you need to do this, why not connected rooms or unheated rooms or duplexes or apartments are a problem. Nor does the comprehensive plan of 2009, which leads to the next statute, NMSA 321-5A, the regulations and restrictions of the county or municipal zoning authority are to be in accordance with the comprehensive plan. In Section 2, residential development of the comprehensive plan adopted in April 2009, it is recommended that allowing accessory dwelling units or casitas on larger lots, ours is 4 acres, could also be an option in providing alternative housing to residents. Additionally, it states close to 55% of the respondents to the public opinion survey supported allowance for accessory dwelling units, while approximately 30% of the respondents opposed allowing accessory dwelling units. The community's support for accessory dwelling units was also clear in the survey you conducted this year during the moratorium, where only 45% indicated that we should ban construction of all new accessory dwelling units, while well over 50% were in favor of various limitations or accommodations that could be established to allow accessory dwelling units. The comprehensive plan policies 231A and B that you cited in the preamble of Ordinance 2104 states the intent to maintain 1 dwelling unit per lot density and encourage socioeconomic diversity. Policies 231C and D that you did not reference explicitly call out the need to establish specific criteria for exceptions to the 1 dwelling unit per lot, like accessory dwelling units, and also to consider larger lot zoning, citing this section in the preamble as justification for outlawing accessory dwelling units when it never recommends this anywhere and expressly directs the opposite is disingenuous at best. Ordinance 2104 was passed in direct and obvious conflict with the village's comprehensive plan, which is a violation of state law.
Mr. Dehoff, I'm just gonna interrupt very quickly. You'd have just over 5 minutes left. Go ahead, sorry.
Point 4, 2104 is unvalidated, invalid, and unenforceable. I'm going to skip through the citation of the laws. The mayor never endorsed 2104, so it is adopted but not validated. But with no enacting clause, it is invalid. Ordinance 2104 was passed in compliance with Corrales Code 261, but 261 is inconsistent with the laws in New Mexico. That invalidates any statute passed following 261, including Ordinance 2104. While you might argue that these are just minor issues, consider applying to these words on the page the same standard of compliance that you are expecting of us regarding Lori's implied unwritten definition of connected, and then tell me you are being fair and just and holding yourselves to the same standard that you hold us. My last point is lack of procedural due process. Section 1845A3 of the Village Code calls out the due process requirements during a denial, states in part that an inspector shall notify and advise the applicant of his findings and the subsequent procedures as required by this article. Neither denial came with subsequent procedures as required by this article, beyond Joe telling us to deal with Lori. And neither denial calls out the specific Village Code sections, even though we repeatedly asked. Failure of both of these drastically limited our ability to respond to or defend ourselves against unlawful taking of our property rights. Lori's first denial is just a declaratory statement and does not indicate any defect against any legal principle. Her 2-line email stated, "I did not hang up on him. He kept arguing and finally hung up on me." It's a separate apartment with a kitchen that is attached to a garage, but no connection to the rooms in the house. The 5-minute phone call to Lori earlier that morning made the denial crystal clear. She insisted a heated hallway between the sections of the house was required, and when I objected, she said, "If you don't do it, you'll never get your fucking permit." And when I tried to object again, certainly more vigorously after that, she ended the conversation by saying, "When you bring me something I can approve, I'll approve it." It's a he said, she said issue of who hung up on whom, but I tried repeatedly and was not able to get her back on the phone that day, and she never reached out to me. I've included my phone log from that day for the curious. The return of our application unsigned without anything more was all we had to work with. We were left hunting for a solution. We did not and do not want to add that hallway. A reference to the village code would not only have been the polite thing, it is the legal minimum requirement under the village code as well as the United States Constitution. The second denial, I'm speeding up. The second denial is nearly as bad. Joe sent us a copy of Ordinance 2104 as he was instructed to by Lori. But again, the denial failed to mention any specific actionable defect. Lori's letter a day and a half later only restates her complaint about the first submission and crystallized the connected definition she had been using against us. But this time the home was called a duplex. Again, there was a failure to cite anything specific. We sent a registered letter to Lori. I'm not going to read it to you. It asked for her to provide specifics. She has never responded. Our final submission that was approved has the contiguous and heated space between all rooms of the house, accessible through the same door as her denials of July 19th and 20th required. We believe that any one of these 5 defects are sufficient to invalidate Lori's decisions, which were based on Ordinance 2104, and ask you to consider these defects and vote to overturn her denial and allow us to build our 3-bedroom home as first submitted July 16th. Additionally, given the defects noted relative to state law, we strongly believe Ordinance 2104 to be invalid and recommend its removal. And a question remains that you have to answer. If the council's intent is not to enforce Lori's definition of connected, then her denials of our permit based on her notion of connected was not only arbitrary and capricious, they were also acts of prejudice, fraud, and malfeasance, and consequences are required. All right, thank you.
Thank you, Mr. Dehoff. I would actually like our counsel to address Mr. Dehoff's legal arguments, which were regarding the ordinance passage, and I know you took them down. Randy, could you address those for us, please?
Certainly, Mayor. I did get Mr. Dehoff's submission that he sent this afternoon, but I obviously didn't have much opportunity to spend time with it, but I did listen to his argument tonight. And I'll take the issues as I think they were presented. The first issue is about the legality of the passage of, it would be good if somebody muted
Somebody
themselves.
needs to mute, please. Thank you.
The first issue was the adoption of that ordinance. And in
Okay.
fact, it was adopted pursuant to the requirements of state law. It states that it is hereby ordained, ordered, and approved, and gives the specific date that the action was taken, and it has your signature. And that is what state law requires. So there is not a defect in the adoption process.
Can I, Randy?
Notice.
No, we're
well,
going to allow,
Let me finish, and then you'll have a chance to rebut.
All right.
Secondly, there was a question about adequate notice of the publication of the ordinance. State law requires that notice be given of actions upon an existing ordinance or the creation of a new ordinance with enough specificity to know what section of the code is being addressed, and therefore give people notice if they're interested in that. The notice was sufficient, I believe, under state law. Third issue, I guess, is the issue of whether or not we're in violation of state statute in regards to the multi-generational living quarters. It's important to note that nothing in that section of state statute 321(1) F or G requires 2 dwelling units on one lot. It simply requires that there be a second living quarters supplied, and it can be done in the same dwelling unit with a second kitchen being allowed in a separate suite within one dwelling unit. So that is not correct that our law is in violation of state law. Mr. DeHoff raises a very good point in that how do you interpret this law that we passed? I think the most, and given the nature of his submission of essentially attaching something to a firewall in the garage, the garage walls are required to be firewalls, and it essentially, under his argument, could allow for a condominium, a townhome, a duplex, a triplex, if they were all under the same building, connected by a wall, such as they did in this particular instance. The problem we have I am sympathetic to the DeHoffs in this way. We currently, under our current code, and not just the amendment that was done in 21-04, under the previous code, only one dwelling unit was allowed per acre. As is mentioned in his argument about the discussions that were had in the comp plan process in 2009, this has been debated for a very long time in Corrales, but the code has never changed. There's never been two dwelling units allowed on one lot. And 2104 attempted to clarify that. I think this case illustrates quite nicely that that wasn't a seamless and clear process. Mr. DeHoff argues that the interpretation was improper by the planning director in regard to how to define connected. Well, I think connected is clear, and I think that her further description of what connected means, connected to the existing space within a home, is a perfectly reasonable interpretation of what connected means. Under Mr. DeHoff's definition, as I said, you could have several dwelling units connected by adjoining firewalls together, and that is obviously not the intent of the zoning code. I may have missed, talking about due process here, I do want to ask Lori about the denial letters that were sent, and just, I think when we're done with this issue in regards to our discussion about the legal issues, I think it would be worthwhile for you, Madam Mayor, to seek information in regards to what the denial letters were, how specific they were. And with that, I'll stand for any questions.
Counselors, do we have questions for our counselor on his responses?
Mayor,
Yes,
this is Counselor Murray.
Counselor Murray. Thank
Well,
you.
the problem I'm having is trying to digest all this stuff at one time. So please bear with me. And I would ask Mr. DeHoff to respond to this question if he would. When you talk about section 18, are you referring to the entire chapter 18, or are you referring to a specific section within chapter 18? Because when you say section 18, I look at chapter 18 and then look for a specific section to that part of it. So please clarify that for me, would you please?
Would someone please mute? We have background Zoom noise. Thank you so much. Mr. DeHoff, please go ahead.
The arguments, some of the arguments have different scope, and so I did simplify when I said section 18. Most of it is the definition, and the accessory dwelling unit shall not be used, or accessory units shall not be used as a dwelling unit. But you know, I think that the requirement for the for the multi-generational housing is a statement that takes chapter 8, section 18 as a whole and says because it nowhere accommodates, I guess I was looking for a special use. And again, why wasn't it made available to me? It could have been done, could have been implemented anywhere in section 18, and it's not in section 18. Therefore I say the whole code doesn't support it.
Does that answer your question, Counselor Murray?
I would like to get the terminology out of the way. Let's call chapter 18, chapter 18. Any section within that should be chapter 18 dash whatever section it happens to be.
All right.
I want to make sure that when we get done with this, we are covered and we understand fully what you are asking of us.
Madam Mayor, I have a question, if I may, for Mr. DeHoff.
Yes, Counselor Parker, correct?
Yes. Mayor Rowe, councilors, Mr. DeHoff, Ms. Stout. When you wanted to do this project and you filed this for building permit, why did you label this space a casita?
It's standard nomenclature, a dwelling, put it in, and they said, oh, this looks like a casita, and we just never changed it.
Okay, and then another question for you. Your original plans had that area labeled as a kitchen, and although you're not showing appliances in it, if you label it as a kitchen and it's approved for a kitchen by definition of the building code. And so are we to look at this plan that you're submitting with that area called a kitchen?
It's labeled as a casita kitchen, not
Right,
a kitchen,
but
right? It's a
kitchen-
casita kitchen. And, we started our plans, last year under the old ordinance, and, Lee told us, so long as you don't have, the oven and the cooktop, that you can, do that. So the whole plan was kind of based on the old ordinance.
Right, and so if we have to make a decision based upon the new ordinances, are we to analyze this submittal with you calling that area a kitchen, meaning a kitchen in all of the definition of the zoning ordinances?
It'd be a really easy thing to say no. I mean,
Okay.
yeah, it's not a kitchen, and I think our testimony at the July meeting said we're not intending to cook there. We're not intending to eat there. We're intending to handle, what comes out of our property there.
I understand that, but as far as the plans go, are you wanting it to say kitchen in the drawings or no?
I go back to the comment that I made to Lori is that I don't consider the label all that important.
Well, unfortunately, the label is
It's everything.
indicative of definitions of our building code, and so we have to follow that. So I guess I
Okay,
kind of
so-
need to know, is it going to be labeled a kitchen? Is that a yes or a no?
It could be a no. Say
Okay,
no.
and then my last question is, I'm looking at page 12 of the original appeal document, and it's got some kind of SketchUp rendering of the space there. Did you create that?
Page 12. I don't know which one you're referring to.
It looks like your floor plan that someone superimposed a couple cars, a bed. the
Oh,
countertop.
that one. Oh, that's from the email that I sent to the mayor.
Yeah, so you created that layout there?
Yeah, that was our early render. Yeah.
And so is this what we're supposed to look at that you'll use this space for?
No. The plans are the
No,
record.
I understand what the plans are, but there's a big blank area where the eating table is, the sofa, the coffee table, the TV, and then it looks like a desk area. So those are just taken out. So I hope you can understand why there is some issues that the village is having with this area, because as this drawing shows, and labeling that space as a kitchen, you actually do have everything that would be required for this space to be labeled as a dwelling unit and thus not be allowed, because only one single-family dwelling unit is allowed on the property, whether it's connected or not connected. And so I guess that was just where my questions are. So I thank you for your time.
Any other questions? Yes, Counselor Burkett.
Right, so I guess let me just finish that diagram was just something I pulled up quickly, and it was about a year old, and you know, we've been dealing with this for over a year with Lori and Lee, and so that was, you know, at the time I was emailing to the mayor and I wanted to express myself. So I think if you look at the entire text of that, the entire text of that email, you know, just kind of express, this is kind of what, this is an indication of what we're trying to do. And I guess I would go back to, you know, we had two rejections. The second one, it's a workshop, it's an office. It's not, you know, it can't possibly be assessed as a dwelling unit.
Thank you, Mr. Dehoff.
Yeah, I had one more question, Madam Mayor. I forgot to
Okay, and
ask
then
you.
I am going to let Counselor Burkett get his question in. So yes, please.
And I apologize for hogging this. When the intent is for have someone stay here at your house when you're not there, so they're going to be living in your house and just sleeping in this area? Is that how? It
Yeah, you know, weekend housekeeper taking care of the horses, that kind of thing.
But right, so if they want to go inside the house and cook something, that's allowed? That's the intent?
Oh yeah, absolutely.
Okay. All right, thank you.
Counselor Burkett?
Yep. My concern, I guess I have several concerns and they all revolve around the same thing. I don't love the fact that the intent of our code can be completely changed with the addition of a door into the heated living space. And I understand from a village standpoint why we're doing that, because that connection makes them distinct properties. But the opposite side of the same coin, I'm curious what living hardship having that door into the utility room from this other structure creates, why this final version of the plan that was approved is not acceptable if the people in the add-on casita will have full access to the house anyway, as you just previously answered to Councilor Parker's question. What hardship does this door to the main property create?
You know, I had to re-engineer what we had. I had to move HVAC. We had to add heating to about, I don't know, 200 square feet that priorly wasn't heated. We had the cost of the door. And we end up with 3 doors on a, you know, 3 egresses on a 600 square foot area. We don't need that. There's no value to us to have that. There's only cost.
Okay, thank you very much. Do I have any other questions for Mr. Dehoff?
Mayor, Councilor Murray.
Yes, Counselor Murray, go
All
ahead.
right, thank you. Excluding the casita, is this only a 1-bedroom home?
It's our permit is for 3-bedroom. We have a master bedroom. We have a combination office bedroom, and then we have the bedroom in the casita. So it's a 3-bedroom home.
Okay, well, I was under the impression, looking at your original plans, that this is only a 1-bedroom, because I do see the office, I do see the theater, but I saw nothing that labeled a 2nd bedroom. So I was just curious. This is a single floor dwelling, is this correct?
Yes.
Okay, thank you.
Anything else? Any other questions? I think also at this time, we should probably move on to final rebuttals. Yes, Randy?
Randy, you're muted.
Yeah, thank you. Is there anyone here to speak in opposition to the appeal?
I don't see or hear anyone.
So if there's no one opposing the appeal, Mayor, then I believe you would need to give Mr. DeHoff opportunity for cross-examination of Lori if he wishes. And since they're the only two witnesses, Lori could, I mean, she's not a party to it, so she really wouldn't have an opportunity for cross-exam. So I think finish the counselor's questions, but Mr. DeHoff can ask any questions of Lori if he has them.
Mr. DeHoff,
Am I able to do that now?
you are.
So I'd like to ask, you know, I don't have complete information, but you know, my understanding is that there has been no one else in the village ever had their plans denied because of this connected definition. Is that correct, or can you point to anyone prior to our denial that was ever denied because of this constraint?
Mr. DeHoff, there was another set of plans. It was actually around the same time as yours. It was actually about the same time frame. They too had a separate, what we considered a dwelling unit attached to a garage. And we called them and told them they would need to attach that to the same contiguous heated square footage, and they are doing so.
Can you give me more details on that? When you
Well,
said around the same time, was it before or after?
they submitted them April 19th, 2021. We were waiting for the outcome of the ordinance, you know, after the moratorium expired, there was the ordinance being enacted. And as I stated, we struggled once it was passed to come up with a definition that would apply to all, an interpretation rather, that would apply to all. And the discussions that I had with our council were ongoing until we came up with contiguous heated square footage and primary entrance. So this was submitted to us on April 19th, 2021.
So can you speak to the casita that was approved on June 28th?
What happened on June 28th was a bedroom and bathroom. And in hindsight, I wish we hadn't approved it. We were still struggling to figure out what was allowed. There was no kitchen. The building official felt that it could be approved. We both felt it was awkward. I wish I could take it back. It doesn't have a kitchen, but in hindsight, I wish I could take that one back. I made a mistake. And subsequently, now that we have talked about the contiguous heated square footage, same primary entrance, that gives us our interpretation going forward.
So there is no precedent for applying this prior to our home. I just want to be clear about that. There is no precedent.
We did not approve any designs with this, with a house attached via a firewall either. Not only did we not deny any, we didn't approve any because we didn't get any. Back then, what we were getting was separate casita type configurations.
All right. I've got a question for Randy.
Sir, I'm not a witness, but I guess if the council wants to hear an answer to a legal question, throw it on out there.
Seventeen 4B that states within 3 days after the adoption of an ordinance or resolution, the mayor shall validate the ordinance or resolution by endorsing approved upon the ordinance or resolution and signing the ordinance or resolution. So I read that to require two explicit acts, and it sounds to me like you don't read it that way. Is that a correct statement?
You're
Randy,
muted,
you're
Randy.
muted.
You're muted. You're muted.
Sorry. I hear you. The case law that was attached to that section there clarifies that if you have a typed language for adoption and a date attached there to the end of the ordinance and a signature by the mayor, that section is satisfied. And that is the common practice by municipalities throughout New Mexico. There's a typed language at the bottom, just like ours, for it is ordained and adopted and approved, and then a date, and then the mayor's signature follows with an attestation by the clerk, and that satisfies the state statute.
Mr. Dehoff, excuse me, I think that's been answered. I don't actually think we should be having these. I think we've got your position and we've got our attorney's position on that. I do want to know if you have any more questions for Ms. Stout.
I think we have covered everything.
Okay, thank you. Thank you very much. All right, now at this point, Ms. Stout, do you have anything you feel you need to address before we move to the final summation if Mr. Dehoff wishes it? And I close the hearing.
Mayor, council, I guess I just want you to understand the basis for the original denial, and which was also the basis for the subsequent approval. We felt that a duplex or apartment type situation was not the intent of the code, but that if the living units were all connected via same contiguous heated square footage, same primary entrance, that went with the spirit of the code, and that was something that was approvable. And that's why we did this. We didn't want to see duplexes, triplexes, townhomes, because we didn't feel that was that's what you intended. Thank you.
Thank you. Mr. Dehoff, oh, Councilor Murray? You
Yeah,
have
thank you,
something?
Mayor. Just a quick question for Lori. So this application never made it to the Planning and Zoning Commission for approval or denial?
No, Counselor, building applications don't go to the Planning and Zone Commission. They go to the building official, and then I do the final zoning approval only. They don't go to the commission.
Okay, thank you.
You're welcome.
Mr. Dehoff, do you have a final summary?
No, ma'am, I think I've completed my statements.
All right, thank you. Thank you very much. I appreciate it. I'm going to declare that the hearing is now closed. I'm also going to ask if the council would like to make a motion to deliberate in closed session as is allowed under the Open Meetings Act. And if they do, one of the counselors is going to need to make a motion for me.
Mayor, I would move that we move this session into closed session for discussion.
I second.
Second, all right. Now, what I'm going to explain is that the meeting of the governing body now, I'm going to take a roll call vote, but I do want to go over the legal basis for this. We can go into closed session pursuant to exceptions under MNSA 1978, section 1015(1), for purposes of deliberations by a public body in connection with administrative adjudicatory hearing. I'm going to go ahead now and take a roll call vote for that. So Councilor Waldman,
Aye.
Councilor Murray,
Aye.
Councilor Parker,
Aye.
Councilor Knight,
Aye.
Councilor Burkett.
Aye.
All right, thank you. At this point, the meeting is now closed. So we as a deliberative body are going to be moved to a different room, and then we will come back to you with the decision. And I'm now going to wait for that to take place. And I think that's going to have to be Aaron Hewlin.
Madam,
Yeah.
my understanding is that the vote needs to happen in the open meeting?
Absolutely, sir. What will happen
Okay.
is we will deliberate, but all votes and decisions will be taken in public after the
All right.
meeting is reopened.
And Madam Mayor, Madam Mayor and Council, you should see a window pop up to join the room. Please just click it, and then whenever you're done, please just message me and we will reopen the session.
All right, I'm going to, because we're on Zoom, I'm going to indicate that now the public has re-entered. We have re-entered the public room. I'm going to now take a roll call vote to reopen the meeting. Counselor Burkett,
Present.
Counselor Murray,
Here.
Counselor Knight,
Yes.
Counselor Waldman,
Yes.
Counselor Parker.
Yes, I'm here.
All right, I'm now going to declare that the meeting is now reopened. Under the law, the matters discussed in the closed meeting were limited only to those matters specified in the motion for closure. And this statement that I'm making now will be approved as part of the minutes under section 1015(1) sub G. So if we are ready to take action, I will take a motion.
Mayor, this is Councilor Murray.
Yes, Counselor.
I move that we deny the appeal for the July 16th drawings, asking for the casita with the bedroom, bathroom, living quarters, and approve the August 5th plan with the connecting hallway.
All right, I'm now going to take a voice vote.
Oh, second.
Thank you. Counselor Parker is a second, and then a vote. Counselor Burkett,
Aye.
Counselor Murray,
Aye.
Counselor Knight,
Aye.
Counselor Waldman,
Aye.
and Counselor Parker.
Aye.
All right, that is the decision of this body. The council has now made a decision, and I'm going to direct our counsel, Randy Audio, to prepare the findings, conclusions, and decision of the governing body. This document will be prepared and will be distributed to confirm this vote, and will be voted on a date we will now decide. Can this wait for our next regular meeting on September 28th, Randy? Will you have it ready by then?
I'll do my best, Mayor, but I would say by the following meeting, if at the latest, but I will attempt to have it done by the 28th.
All right, and if not the 28th, then the next meeting is October. What is the date, Aaron?
It will be on October 12th, Madam Mayor.
Okay, so no later than October 12th, we will have that from the council, and we will be able to confirm the vote at that time. I want to thank all of you for participating this evening. And do I have a motion to adjourn?
Mayor, before you go, Mayor, may I speak?
Actually, at this point, I don't think that is part of the official hearing procedure. So I'm just going to suggest that you wait to see the official conclusion and understand that you have an approval of your August 5th drawing per the decision of the council tonight.
My appeal was for the July 16th plan, so I believe the motion would have to be just to deny that appeal. Is that not correct? Because we already have the plans approved.
That
So you're in
is
effect
correct, but you
doing
are
nothing.
getting an approval. I'm not going to fight with you over this, sir, at this time. You are getting a denial. You did get a denial of that. And as part of that, you also got an approval of the next section of your interaction with the Planning and Zoning Department. So those two things are both true. Okay.
Thank you.
You're welcome. All right, well, if there is nothing else, I'm going to suggest that the hearing is now over and the decision has been rendered, and wish you all a good evening.
Thank you.
Aye.
Good night.